The United States Supreme Court is rapidly running out of time to address some of the most critical constitutional challenges in modern history surrounding two-way issues. Multiple major cases, including a high-stakes challenge against magazine restrictions and also another one targeting semi-auto bans, have been officially rescheduled for conference this week. As the court's term enters its final weeks, we are facing a looming tense deadline that will determine whether the Supreme Court is finally prepared to issue a definitive nationwide ruling on these issues, or if these repeated delays are actually a signal of retreat. This dramatic countdown is unfolding at the exact same moment as the DOJ has launched a very aggressive offensive, filing its own federal lawsuits against various state bans on these types of items. And they openly are actually signaling and stating that they expect the Supreme Court to finally strike down these bans entirely. In this video, we're going to break down the dwindling Supreme Court calendar and why these final weeks of this term represent a very critical make or break moment for a lot of Americans and currently their two-way protections. So let's talk about what is happening. Now, before we break into the critical details of this looming Supreme Court timeline, I just want to say that if you want to support the channel, please hit the subscribe button and also click on the notification bell, and you can find all of those down below. So as I mentioned, we are officially entering the final countdown for the United States Supreme Court and the looming blockbuster decision on the future of some massive Second Amendment cases that have nationwide implications. And this is rapidly heading towards a deadline because the Supreme Court term is about to end. In a new development, the California magazine restriction challenge and also the semi-automatic hardware challenge out of Illinois have once again been rescheduled for conference this week. With only weeks left before the court closes its doors for the summer recess, the calendar is dwindling down and the pressure on the Supreme Court to finally step in and rule on these sweeping restrictions is reaching a very critical breaking point. But making this looming deadline even more explosive is the fact that the DOJ has recently launched its own aggressive offensive, openly filing federal lawsuits and signaling that it expects the Supreme Court to eventually strike down all of these state prohibitions. And for many of you viewers who maybe have grandfather magazines in states like California or rifles also in other states, with these types of cases in front of the Supreme Court, this is going to impact you depending on what the Supreme Court decides to do. To set the stage, the two major petitions currently sitting in front of the Supreme Court are the Duncan magazine restriction case and then also the Vermontes hardware challenge out of Illinois. Duncan directly targets state-level prohibitions on magazines holding more than 10 rounds, which the Ninth Circuit previously upheld. Meanwhile, the Vermontes case challenges sweeping restrictions in the state aimed at the most popular, commonly owned semi-automatic rifles in the country. So together, these two represent the single biggest unresolved constitutional questions regarding the scope of individual rights and the right to keep and bear these arms. Now, recently, these issues actually intensified after you had various states attempt to block the Supreme Court's intervention and also pointing to separate appellate court developments and rulings. For example, in the Benson challenge, which we've recently discussed out of Washington, D.C., there was an original panel who had successfully struck down a very similar ban on magazines. However, the decision was directly vacated for a full court rehearing. The states in these cases immediately notified the Supreme Court, arguing that because the lower court decision was temporarily wiped out, there was no longer an urgent reason for the Supreme Court to intervene and review these issues. But it's yet to be seen right now if the Supreme Court even wants to get involved. We have to look at, kind of the cold hard data, which is at this point, we have currently the 20th time that these two cases have been relisted and rescheduled for internal review and been sent to conference. In the world of Supreme Court litigation, a 20th relist is a double-edged sword that could indicate a serious warning sign. On the one hand, it confirms absolute sustained interest potentially behind the scenes. The Supreme Court has essentially repeatedly denied review to multiple other high-profile constitutional two-way challenges. And as of right now, they have refused to just outright deny these two-way cases. Instead, they are actively keeping them alive for conference, one after another. On the other hand, reaching a 20th relist without a definitive decision to grant review can actually signal deep fracture or hesitation among the conservative majority. It can mean that the court is deadlocked on the scope of the opinion that they want to issue, or even worse, that they are waiting to pass the buck entirely, maybe to future terms. With the final weeks of the calendar winding down for the Supreme Court term, these upcoming days represent a definitive kind of make or break moment to see if the Supreme Court will step up or if the clock will essentially run out. What makes the 20th conference cycle, and relisting entirely unprecedented is that it's unfolding alongside a historical kind of structural shift inside the Trump administration, the federal government, and the DOJ. While the justices deliberate internally, the federal government has launched a very aggressive, direct offensive against state-level overreach and these bans. The DOJ has officially filed major federal lawsuits against local prohibitions in the city of Denver, and then also the comprehensive ban in the state of Colorado. The DOJ is explicitly arguing before the federal judges that these items are fully protected under Heller, Bruen, and the Second Amendment. They argue that these are commonly owned items, that they're lawfully owned for lawful purposes, and they're owned in the tens of millions, and therefore they cannot be outright banned. You even had Harmy Dillon, who openly declared that the current administration firmly believes that the Supreme Court will eventually rule that these bans are unconstitutional nationwide, and more importantly, that the DOJ intends to actively help to force that outcome. So legally, these new DOJ lawsuits are independent actions separate from these Supreme Court petitions that we're talking about, but strategically, they completely alter the environment for the Supreme Court. Previously, these landmark appeals were driven solely by private individuals and advocacy groups. Now the federal government itself is stepping into the arena, actively pushing the exact same constitutional theories directly towards the High Court's review. And the pressure on the Supreme Court is reaching a very critical boiling point. The lower court friction continues, the calendar right now for the Supreme Court is running out, and the federal government is openly demanding a uniform, nationwide ruling to settle this conflict once and for all. Realistically, we may not get an immediate announcement following the conference this week or maybe even next week. The Supreme Court could also add conferences and kind of do this during a cleanup conference if they're going to grant, deny, or maybe even push this out to a later term. The Supreme Court still has the procedural power to relist these once again, hold them, deny them, push them out to another term for a hold. But the fact that they have survived 20 rounds of conferences proves that these at least are receiving some attention behind closed doors, and at least maybe some of the Supreme Court justices are considering this, or maybe even a dissent is being written if these are going to be denied. So the countdown currently is on, and the federal government has joined the fight, and the upcoming weeks and conferences will dictate the future of these critical two-way constitutional protections. As soon as the court releases its decision on these cases, I will bring that straight to you guys to let you know, because again, this impacts a lot of us, including me in California, because depending on what the Supreme Court does, like for example in the Duncan case, could impact a lot of these Freedom Week magazines and grandfather magazines that people currently own. So as we get that information, as that happens, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.